Hello everybody, it's your friend Rick. It is September the 8th, 2017. If you need to contact me, it is rick0327 at me.com. Alright, and you know, if you look at my videos like over the last month or whatever, you see a lot of the writ of mandamus, and it's for a reason. Repetition. Plus, it's my game plan that we gather all kinds of evidence. Notifying this one, child support agency that we never contracted with them. We don't owe them a debt, because that's what a debt is. A debt is a contract. Okay, that's really what it is. And for getting these, if I was to take 10 responses from like 10 different subscribers from all across the country, the responses are always basically the same thing. The court said that it's not a debt, a commercial debt, which it is. And it doesn't matter that I put in the demand, for validation. It doesn't matter that I put in there that the Supreme Court says it's a commercial debt. It doesn't matter. Or the Federal Court of Appeals says it's a commercial debt. It doesn't matter. They just, what they do is they stick to their game plan, and by sticking to that game plan of saying, well, it's not a commercial debt, they can feign ignorance or feign that what they're doing is lawful. Okay? But what they're really doing is, at this point, after we notified them that the courts have said that child support debts are commercial debts. Now think about this for a second. How many of you are paying child support? You live in one state, but you're paying child support in a different state. Well, that's interstate commerce. Okay? You can't get any simpler than that. All right? It's interstate commerce. That's why it's a federal child support law. Then interstate. So, and that's really where they get their jurisdiction from. Okay? The child support agency is not supposed to be handling a debt within the same state. It's supposed to be handled by the courts. You get it? But they've been getting away with it. Okay, I have the manual, the support manual for attorneys. I covered this months ago, and they got like 12 chapters, and it's for the lawyers. Really, it's for the non-judicial persons, the fake judges, to follow. And there's a chapter, I believe it's chapter 12, modification. It says that it's called intrastate, meaning, let's say you're dealing with a child support matter in the same state, okay? And it says that the court of issuance maintains jurisdiction. Okay, but here's the thing. These family courts, they do not have equity jurisdiction. They're not allowed to issue money judgments. That's really what they are. Okay? So, but what they do is they issue these fake orders, and they give them to these child support enforcement agencies, and they claim, well, that's where we're getting our authority from, to enforce the child support. Okay? So getting back to the response from the child support agency claiming, well, it's not a commercial debt. It's child support. It's a court-ordered debt. See how the scam works? A fake court order is issued. The child support agency feigns ignorance. We got a court order. Meanwhile, it's not a court order. That's why the writ of mandamus is the way to go. It's the only way I see to go. Because if you go inside a court of law, and you're going to be before a judge or submitting papers, even that judge can't, as much as he or she would like to keep this fraud going. A signature from a non-judicial person, quorum non-judice, is not a valid court order. And we got a shitload of case laws to support it. We could also make an argument that a judgment without a judgment by your peers, how does that happen? Trial by jury is void as well. Okay, so we have all of these things working for us, that it's a void judgment. And this is why they're running away from us. But I got a guy in upstate New York right now who is filed a writ of mandamus against the child support agency. And the county child support agency, and guess what it's going on right now, I'm helping them right now, is they didn't respond. They didn't answer the pleadings. So they're in default right now. Why do you think that is? Because they cannot answer it. They cannot provide a court order. That's why my game plan is the way to go. Okay? Take some persistence. That's why we have to, reach out to these people to give them the opportunity to fix it first. We don't want to give the courts any reason. That's why you got to follow these court rules and stuff. All right? So the way to go is validation of debt. Now, in my validation of debt, I cover that. So one of my subs, she sent me the response from, it was in California, and it was, this is what I'm referring to. Well, it's not a commercial debt, it's a child support debt, it's a court order debt, but in the validation of debt, I cover all these things. I'm like, well, if you're going to say it's a court order debt, give us a copy of the court order. No court order. Now, I told her the next move is the writ of mandamus in her state. Okay? The courts have to order these people to show to show the court order. Now, getting back to my guy upstate, he's going to be entering the default judgment. Now, the way things are looking, if they can't show that court order, guess what? All that money's got to come back to him. That's what's going to have to happen. We'll see what happens. I mean, when it comes to money, these courts, forget it. When it comes to this, because you got to remember, these are state courts, and we're trying to get state money back. So these courts, they're not impartial. They claim to be impartial, but they're state courts. They work for the state. The judges, they're state judges. They work for the judges. Even though, a lot of them are elected judges, we know that their loyalties are to the state. I mean, it cannot be a coincidence that we cannot. I've been doing this for with helping people since the beginning of January with the affidavits. So I've been dealing with a lot of emails. Probably like 4,000 or 5,000 emails. At least a couple of thousand emails. All right, I showed you one day. It's 74 emails in one day. All right, so let's just say 8 months, 30 days, 240 days, at least 20 a day. We're talking at least 1,000 emails. I deal with way more than 20 a day. So my point is that not one person has run into a sympathetic judge. Why do you think that is? Because they're not sympathetic. Besides not being sympathetic, they're following a mandate. They're all mandated. Get as many of us into the system as possible. How do we thwart that? By exercising our rights, knowledge, right? They call it a belligerent claimant. And I said this a few months ago, like I saw a case law from the Supreme Court or some high court that said that in order, your rights are basically worthless if you're not belligerent. You You have to be belligerent. Now, certain judges don't like when you're belligerent. That's the tightrope we have to walk. Okay? In my video where I'm going against that judge, at some point I got, even though he was a nice guy towards me, but he wasn't, he still wasn't giving me what I wanted. I was like, listen, Judge, you're a nice guy, but I'm sorry, I have to demand you show me jurisdiction right now. Because I was like, I wasn't walking out of there. If you watch the video, I was a mess. I had $7 in my pocket. I was a fucking mess. Beaten down. And he gave me a stay and then eventually got it vacated. But the thing was, I could not be belligerent to the point where I really, some people are like, well, you gotta fight. You really, sometimes you can't, or you cannot. Because these judges just get up and walk out and then you're screwed. Okay? So, there's a lot of different things going on for us. That's why this is very, very difficult. That's why it's important that you learn as much as you can. You watch videos, you watch other videos of people. I haven't seen anybody. There's not too many videos on YouTube of people really winning. All right? They don't want that to happen. Okay? That's why, like the straw man stuff. Listen, I know all about the straw man, and I know it's true. But I don't think you're gonna win. You're not gonna prevail in court with it. Okay? The only way to prevail is to use their rules against them, their case laws against them, and our evidence. I mean, we're right. The one thing we have going for us is that the orders are all void. You know what I mean? You can't get any better than that. And then, now we're at that point where, I've been pushing this writ of mandamus now for, a month and a half, 2 months now. So, we're getting to that point where a few people have started to implement it. And, the pattern is that, I showed you the last video where, a 7-page motion to dismiss, and this is the same type of shit that I dealt with in the federal court, where it's like set up with the attorney for the state or for the city, for the county, whatever, submit some, BS motion to dismiss, and then the judge grants it saying the petitioner failed to state a claim. Except, as I pointed out in my last video, there is no, you don't have to state a claim to demand a judge to show jurisdiction. It's going to be a little difficult, because that's why they were playing games calling it declaratory judgment. So I can tell you this, in my writ of mandamus papers, I put in there, we're not seeking a declaratory judgment. Just like one guy went to court yesterday and did good, and in California, and they were reading the paperwork, and the fake judge and the attorney on the other side were playing dumb, going, I never heard of this injury in fact stuff. And he's like, well, did you read my paperwork? If you would have read my paperwork, I'd tell you what it is. Basically what it is the, I put in there the Supreme Court decision explaining what it is. So every petition brought into a court, if it doesn't fit that 3-pronged injury in fact minimum, and it's called the irreducible constitutional minimum standard, right? Concrete injury in fact, some type of causal conduct by you that caused that injury in fact, and the likelihood the court is going to successfully redress and remedy the matter. So as they're reading the paperwork, the commissioner goes, oh, he's a constitutionalist. And then he objected, but now this is what I want you guys to do. Anybody ever call you a constitutionalist, you go, objection. I'm not a constitutionalist. You are. You're the one with the oath of office sworn to defend the Constitution of this state and the United States. You're the constitutionalist. You're supposed to uphold my constitutional rights. You're supposed to be my advocate for my constitutional rights. That's what the whole purpose of their oath of office is. Then also there's the Supremacy Clause, Article 6, Section 2 of the Constitution, that says that every officer of the courts, it doesn't say that, but the judges, the courts. If it says the courts, that goes for the judge. When a judge is in the court, the judge is the court. You understand? He or she is representing the court. So if it says the courts are supposed to enforce the laws and the treaties and the Constitution of the United States, that's it. And any law that doesn't well, there's a law that conflicts with your constitutional rights, it's unconstitutional. Okay, so that's what we're dealing with. Also, I'm gonna end this video real quick. I don't know if I ever told you guys this, and if I did, I'm sorry. I should have told you. When you go file your paperwork, always bring 2 copies. One is for the court that you're filing. One is for you to have stamped. That way, you have a copy of the stamp. They'll know exactly what you're doing. So when you hand it in, you're going to say, this is the original, and this is a copy for my records. That way you have a stamped copy. All right? And that's about it. We covered what we had to cover, and I'll talk to you guys soon. Bye.